Dear colleagues, dear participants, dear friends, we should really thank Aurelio and the organizers of the conference because we have left the headaches for the last session. That means intellectual property and the metaverse. On this very special occasion, we want to ensure that the headache doesn't last too long. So we will try to finish not exactly on time, but not that far from the planned time. So as such, I would wish to give the floor right away in the order of the program. Well, first of all, I should perhaps introduce myself, but it's already late in the afternoon, so I met many of you. I am Laurent Manderieux. I'm professor at Bocconi University. For the last 20 years, I have also a kind of public double life, having advised authorities all over the planet on intellectual property lawmaking and on intellectual property and technology lawmaking. And I'm the chair of the European Intellectual Property Teachers Network. So I'm super happy to be here in Alicante again at the invitation of the organizer to have with us today 3 exceptional presenters, not to talk about the super exceptional discussants who will be with us this afternoon. So at this very stage, I would wish to give the floor first to Sara LOUREDO, who is Assistant Professor of Commercial Law at the University of Vigo. So completely, she had to cross the whole of Spain to be with us today and to enlighten us from Atlantic views, or transatlantic views in this case. Sara, the floor is yours.
Yeah, thank you very much. Yeah, and maybe I can have the device to pass.
Oh, you want the device? Yeah. Okay.
Okay, yes, thank you.
I am very primitive, I never use it. Okay, fine. I use my computer.
It's true that I had to cross the country, but well, some of you have come from farther, and it was completely worth it. So thank you for having me, thank you for the presentation, and I'm very honored. And also congratulations on the organization. I have chosen the title, I think, oh, sorry, it's not projecting, I think, oh yes.
Yes, it does.
Yes. So I have chosen this title, Metaverses and Industrial Designs, Opportunities and Ambiguities, because I think the metaverse, as we have seen in previous presentations, is an environment that is quite challenging, but at the same time promotes very well innovation, creativity, and also it has commercial added value, as we will see. So, first of all, industrial design. What's exactly industrial design? Because sometimes we talk about it, but we don't have a proper definition. And I will try to give one according to European Union legislation that we will tackle a little bit in the next slides. And we may rephrase the article that that regards this topic, the definition. We may say that design is the right that protects the appearance of a product which results from external attributes of that product, such as its shape, colors, or materials. So we may think, well, this has little importance in comparison to other IP rights, for example, patents. Patents seem always like the most serious thing, the important thing to protect. But I like very much this sentence from industrial designer Raymond Loewy that says that between 2 products equal in price, function, and quality, the better looking will outsell the other. And I think this is true, and also we can relate to this as consumers. We know that with the same function, we tend to choose the product that we like more, right? So, the characteristics of metaverses have been studied by people. Some of them are here, and so I will not stop here in order to make my presentation a little bit briefer. But I will say that processes linked to industrial designs in metaverses are of 2 types. The first type is regarding those products that are completely digital, and so are, for example, clothes worn by avatars, without any dupe or any twin, we can say, in physical form. And the second process is the one that I want to show in this photograph down, it's a Walmart shopping experience in which we have digital products, but in the end, what we are going to acquire and have at home is the physical, real product. So we have a dupe or a twin. We have a physical product and a digital one. So now the regulation. What we have exactly right now in designs? Well, we have something that is about to change soon. We don't know exactly when, but soon. Currently, we have two instruments on a European level because industrial design is regulated both on a national and a European level, European Union level. So the last one is the one I will focus on, and we have now in force two instruments, a directive from 1998 and a regulation from 2002. They do not contemplate metaverses, of course. They are a little bit old for metaverses, but they have a virtue. They are open enough to be able to comprise many things regarding metaverses or new technologies that may appear. And so I think this is the main virtue, and it's not something to be disregarded. But since 2022, two proposals, two drafts for directive and regulation have appeared and are under review right now in the European Union. And I think two developments are quite in line with the metaverse reality. The first one is that the definition of design now includes things as movement, transition, and animation, as well as objects that only have a digital form. So apparently, digital designs, if we had doubts, in my opinion, no, but if we had any doubt, now they are expressly included as possible designs to be protected by the regulation. And the second one is the fact that the use of a design in a context of parody, critique, or satire would not be considered infringement under certain conditions, and these are important, as we will comment in the next slide. So, infringement. Infringement is an article that is not going to change in the proposed regulation, and so it would be the same as it is now, which is what you have in the upper part of the slide. The aforementioned use, the use that is considered infringing, shall cover, in particular, the making, offering, putting on the market, importing, exporting, or using of a product. So this apparently does not change because these uses, these actions will take place in the physical world, but also in the digital world. So again, open enough or broad enough to have the actions in the physical world, in the digital world. Okay, but the problem is here. The fences are being interpreted in a broad way. For me, in my opinion, in a too broad way. Why? Because, first of all, when we use a design as part of decoration or ornamentation of a shopping experience or a video game, if that object particularly is not object of commercial transaction, it's there only to enrich the experience. In that part, in that photograph, you can see that that is a Ferragamo shopping experience for Christmas. It was like, I think, 2 Christmases ago. And you could shop things from Ferragamo in this environment that was like an Italian villa. So the decoration, the furniture, you could not buy because it was not Ferragamo, but it was enriching the experience. And so when this happens, apparently, there is no commercial use of the ornamentation, and so you should not forbid it as a right holder. Well, I think this has many problems, but let's leave it there. And the second one is what we have commented about parody. Now the regulation is proposing to include a limitation of use when there is parody. And so what they say is that this parody has to be compatible with the fair commercial practices, and only if it is not an undue harm for the normal exploitation of the design. So it's going to be important how we interpret these things, right? And also because recently the two Northern American courts have found it was relating to trademarks more than designs, but designs were also in the case. It was the Meta-Birkin case, and I think Joanna is going to tackle it a little bit, so I will not detain myself in that. And this case that is Ryder Ripps, who is an artist, that tried to make a parody, or so he said, about a collection of NFTs, art that were called the Bored Ape Yacht Club. And so they said, we are doing the same. In both cases, they said freedom of speech, and I am doing the same as Andy Warhol did with the tomato soup. It's true that it was copyright, no industrial design, but industrial design was also involved, I think. And so the jury in one case, the court in the other one, said, this is pure infringement. You are not giving anything to freedom of speech. Why you are copying something as if you would do it in the street, this would be totally forbidden. But because you are doing it in the metaverse is freedom of speech? Well, no. So I think we have to be very careful, and this is my conclusion, right? To these questions, more than answers, I would say these things. Is the legislation adapted because we say now digital age, virtual product? I don't think so, but maybe we don't have to adapt it so much because it was open enough to comprise many things that are here in this new reality that is the metaverse, right? So should we include further mention to digital realities? In my opinion, it's not quite necessary right now. It is open enough, and this is a virtue. Should infringement be treated differently in the context of metaverses? I think, well, we have to adapt ourselves to this environment, but we shouldn't be more permissive with things that are made in the metaverse than with things that are done in the real world. For example, this parody, right? Because it's very easy to make a parody or say that we are doing it with the anonymatum that covers the metaverse, with no territorial barriers, with more difficulty for persecuting infringement, so it's very risky. And in the end, are metaverses in general enabling or hostile environments for designs? I would say that are a little bit both. I'm Galician, so we say it depends. Well, it's a little bit like it depends because on the one hand, they are enabling for example, creativity, for not having to adapt to the constrictions of the real world, the physical world. But on the other hand, are hostile because we see that infringement is very difficult to persecute, for example, no? So thank you very much. I am sorry if I was not brief enough or I could not tackle everything, but well, then we have the debate.
You respected the 9 minutes
okay.
template. That's
okay.
absolutely perfect. So, thank you very much. I would now give the floor to Daylin VALDÉS HERNÁNDEZ was my student at the LLM Carlos III. So I'm very, very proud that she's here, coming from Madrid, and she will talk on the use of NFTs with underlining artistic works in the metaverse. So we are super, super curious to know more on this. And thanks already to Sara. We didn't enter into headaches. We'll leave the headaches for the questions of the discussants. Daylin, the floor is yours.
Thank you. So good afternoon. It is a privilege to be here with so distinguished colleagues. Today I will explore the intriguing intersection between technology and law through the lens of not-fungible tokens, NFT, of artworks in Metaverse. So we'll focus on NFT within the Metaverse. The Metaverse economy will be based on a market of digital assets created by developers to be exchanged with users of these virtual worlds. NFT have unique assets representing artworks are set to play a significant role. In 2023, the NFT market was worth over 22 billion, with a growth trend of 220% since 2021, and is estimated to reach $80 billion by 2025. This growth highlights the potential importance of NFT in Metaverse, much like e-commerce boosts the Internet's appeal. In the next 10 minutes, I will highlight some key issues about NFT of artworks, explaining in layman terms what NFT are and addressing common misconceptions. This will be drawn from a critical review of a recent case of the Commercial Court of Barcelona on January 11, 2024. The case involved a dispute between Mangos Group and BIGAP, the entity managing visual artist rights in Spain. Mangos Group owns the physical media of several artworks by notable artists, while BIGAP manages the copyright. Mango commissioned new digital works by creative artists to make reinterpretation based on the original works. They created Lazy NFT to be displayed on Decentraland and OpenSea without consent from the right holders. BIGAP filed a lawsuit claiming that the online exhibition infringed moral rights of integrity and disclosure, and also economic rights of reproductions, transformation, and public communication. Mango argued that they had the right to display the artworks publicly as the owners of the physical media, and that the NFT were just digital files, not blockchain assets. Questions about NFT reemerged from this case. What are NFTs? Does tokenization constitute a new form of exploitation or a new form of exploiting IP rights? These questions are unsurprising, given the ongoing debate and the widespread confusion around about NFT art. This confusion lies in the speculations around NFT, often presented as authentic digital artworks. This has led to three main myths. First, that NFT result from an act of transformation. Second, that NFT are the medium of the digital artwork. And third, that they are unique public certificates proving authorship and preventing easy reproduction. We believe that these ideas are incorrect. NFT are units of information, specifically asset code registrations with metadata characterized by not fungibility within blockchain networks. An NFT of an artwork is a unique metadata identifying the artwork on the blockchain. On the other hand, lazy NFTs are simply functionality offered by marketplaces, delaying their generation until the sale moment. So NFTs are not works. They do not constitute original intellectual creations. They do not result from an act of transformation. Tokenization, the process of creating tokens through blockchain technology, is not digitization. The work keeps its own digital medium, but now it has a unique identifier on a blockchain. That's all. NFT do not certify a work's authenticity. And the work can be endlessly reproduced, and multiple NFT can be made from the same artwork. And this is because of the lack of an actual relationship between the artwork and the NFT. So the value of NFT lies in the uniqueness and not exchangeability of this kind of assets. Blockchain technology certifies the existence and authenticity of the token, making it not reproducible digital good. However, this pertains to the NFT, not to the reference work. So tokenization is not an act of exploiting the work. it involves generating a simpler digital registration code for a work. However, the token creator often aims to commercialize it, and typically through marketplaces, requiring data like the NFT image, like a title, and a link to the work. So this data is added to the token's metadata, making it visit on a platform. As a consequence, act of communication and reproduction could be involved in the commercialization of NFT. So back to the judicial case, it was presented as a pioneering court case in Spain of NFT. There were high hopes that this judgment would set a precedent for future cases of tokenization of artworks and lay the foundation of the legal nature of NFT. For those who haven't read the judgment, spoiler, none of these expectations were met. This is not a pioneering case on NFT. To be fair, these expectations were unfounded. So, to conclude, here are some key points about this subject. NFT are essentially metadata. The generation and sale of NFT may involve acts of reproduction and public communication depending on the type of NFT and the information provided on the marketplaces. In the case of Barcelona court, the lazy NFT of the artwork were not traded. The lazy NFT information was listed on the marketplace, but it was a great opportunity for the court to rule on this matter. Thank you very much.
Thank you. Thank you for respecting perfectly the timing. I would now propose to give the floor to Joanna Lapatura, who is lecturer in law at University College London. So, on the fair metaverse uses of digitized IP, a European copyright and trademark law analysis. The floor is yours for 9 minutes.
Thank you. Press this. No, this is not mine. It's okay. It's the black and white. Yes. Perfect. So, hello everyone, and thank you very much for having me here today. I'm very pleased to be here in beautiful Alicante and to get to meet all of you today. So, my presentation is on fair metaverse uses of digitized IP from a European copyright and trademark law analysis, and more specifically, the focus is on the digitization of real-world IP content and their kind of tokenization, their minting into NFT form, which is a very common occurrence nowadays, as well as 2 case studies to help examine the notion of use in a metaverse context. The first part of my paper is on trademarks, and the case study is on Hermes and Rothschild and the Meta Birkin NFTs versus the Birkin trademark by Hermes. The second part of the paper is on copyright law, so the case study is Vergop and Mango. So here we have the tokenization of physical paintings by famous Spanish artists such as Miro, Tapies, and their minting into digital fashion pieces, as well as their exhibition in the Metaverse. Now, given that Daylin has already covered this case, I will only focus on the trademark part of my paper. So, first of all, the paper explores whether the metaverse uses in the current facts would amount to trademark infringement under the European regime, under the European legal tests. And secondly, it explores whether the metaverse uses in question could be considered fair under, again, the European trademark law regime versus the US fair use doctrine that was examined in both judgments, as well as whether a balance can be reached between, on the one hand, the interests of IP owners, on the other hand, freedom of artistic expression. So the focus is on artists. Why is that so important? Well, given that the metaverse was envisioned as a decentralized, openly accessible space for everyone to interact with one another, if artists are presented with a high risk of infringement, they would more or less be less incentivized to engage with the metaverse, and this would have a direct impact to the development of the metaverse rather than just an impact on IP. So to begin with, the digitization involves inherently exact reproduction of the IP subject matter into digital form, and then this gets turned into an NFT through minting or tokenization for use in the metaverse, and in some instances without the consent of the IP owner. If we take a look at the Hermes and Rothschild case, and more specifically, we are being presented with, on the one hand, the Birkin famous trademarks by Hermes. By the way, it's a word mark that's being protected, but also the 3D shape mark for the handbags themselves. And as you can see, in the middle, it's the Hermes Birkin bag. On the sides, the Meta Birkins. So they have imitated the design, which is protected as a 3D shape mark also in the EU, not just in the US, as well as the word mark, well, at least almost identical, or at least very similar, for NFT digital wearables in the metaverse. So in the paper, I looked at whether, had these facts been assessed under the European law regime, whether the same outcome, well, infringement, would have been reached. So, in the present case, Hermes tokenized and, well, digitized, tokenized, used, as well as exhibited and sold 100 NFT Meta Birkins for a high amount as well. And Hermes sued, made 2 trademark claims, which I will quickly go through the lens of European law on the basis of consumer confusion as well as dilution. So for claim 1, consumer confusion, if we were to examine the case through Article 10.2b of Directive 2015-2036, as well as Article 9.2b of Regulation 2017-1001, when we're assessing whether the signs are identical or similar, well, Birkin versus Meta Birkin, similarity, even if not identity, is fairly straightforward to establish. Then we need to establish whether the goods or services are similar or identical, as well as whether a likelihood of confusion or association on the part of the average consumer would take place. Now, the problematic aspect with this claim would be in relation to the goods concerned, because on the one hand we have physical handbags, class 18 under the NAS classification. On the other hand, digital NFT handbags would be pertinent to class 9 as either downloadable image files or downloadable digital image files authenticated by NFTs. So it's important to note that at the time of the litigation, Hermes had not proceeded in any trademark registration to class 9. So unless this case would be litigated post these registrations, that claim would have failed. Then, in terms of claim 2, dilution and unfair advantage under Article 10.2c of the Directive and Article 9.2c of the Regulation, again, similarity or identity between the signs. We do not have to worry about the goods or services, even if they're similar, that's fine. And it would be fairly straightforward to establish that given Hermes' conduct, the almost identical design, the sale under the name Meta Birkins, as well as the sale of the Meta Birkins for thousands of US dollars, similar pricing to the actual Hermes products, one could argue that this would amount to This could create a link or association in the average consumer's minds as to trade origin or source, as well as potentially cause dilution, given that well, if Hermes wanted to expand on the Metaverse, there would already be a presence there. That means that perhaps the Birkin mark would not invoke the same association in consumers' minds as it does now. So, very briefly, I'm going to skip this slide. In the US, Hermes won. Trademark infringement on both claims was established. 133,000 in damages were ordered, as well as there was a very broad permanent injunction in June 2023. Now, to what extent can we argue that fair use, when artists appropriate IP content in a metaverse context, digitize it and tokenize it, well, to what extent can we strike this balance between artistic expression and the IP owner's rights? Rothschild's arguments in this context, well, he said, I am trying to convey a message, an artistic commentary on consumerism in the digital age, that people want to pay a lot of money for a digital handbag, as well as the fur free movement in fashion, which is well, something that Hermes is not abiding by. Now, very, very briefly, because I'm running out of time, under Recital 27 of the Directive and Recital 21 of the regulation, artistic expression should be protected if it is in accordance with honest practices. Now, the most likely scenario in cases of artists would be Article 14.1c of the Directive and the regulation, the so-called referential use, where there is use of elements of the earlier trademark to identify or refer to goods as those covered under the trademark. Now, some academics, very, very briefly, some academics believe that parody may now be encompassed within this provision post the reform. However, this referential use defense is bound with, by honest practices. In the present case, as I've highlighted here, given the dilution and economic activity in relation to the use has been carried out by Hermes, by Rothschild, it's very unlikely. But my last point is, in overall, it is submitted that artists' rights is less likely to be upheld when they appropriate trademarks in a metaverse context. Given that, first of all, there is no parody exception. Secondly, the referential use is sort of limited by the honest practices proviso. And thirdly, the finding of infringement under the current legal tests is relatively low, so likelihood of confusion on the other hand, lingo association on the other hand, when we're talking about famous marks, and even if the same parodic use might have been recognized and protected had the content been protected under copyright law, whereas parody is expressly protected under the InfoSoc directive. Thank you.
Thank you very much. We will have one of our speakers, for very unfortunate reasons, couldn't make it, but will be connected online. So Vanessa, I'm super happy to greet you. Vanessa JIMÉNEZ Serrànía, who is associate professor at the University of Salamanca. And unfortunately, she has to do the presentation, well, actually from home. So Vanessa, the floor is yours. As we are running late, we are all respecting very well the 9 minutes template. So please go ahead. Thank you.
Thank you very much, Professor Mandeliu. First of all, I would like to sincerely thank the Congress organizers, especially Professor Aurelio López Taruela, for allowing me to participate remotely in this excellent Congress and in this magnificent panel. I will love to be with you and discuss this subject in person, but as you know, it was impossible for me, unluckily. I will share a presentation and I will try to respect the time. Okay, I will make the presentation in white. Okay, perfect. So in order to adjust to the time, I will give an overview of what I discussed in the paper, and then I will focus on some of the aspects that I consider to be more controversial. As we know, metaverses are the platforms of the future. In fact, they are more than platforms. They are the ecosystems of the future. Like in any digital ecosystem, we will find important challenges from the point of view of intellectual property and competition law. The development of metaverses and the activity that take place in them will involve the emergence of innovation and creation that will potentially be protected by intellectual property, and that will condition both the access and the activity of the platform. This situation is not new, considering that we have already experience regarding the Web 2 platforms. Nevertheless, as we can see in this slide, we find a series of new elements that I would like to highlight. Firstly, thanks to blockchain technology, in addition to centralized metaverses, we discover the metaverses whose governance will be decentralized. These metaverses are structured as a decentralized autonomous organization, and the decision-making process belongs to the members and not to a central entity. Secondly, tokenization has a substantial impact on many markets, with a growing importance in cultural and financial markets. Finally, interoperability is one of the key aspects to be taken into account and encouraged in order to allow innovation and the possibility of the existence of a plurality of metaverses. These virtual worlds, as we can see in the slide, raise very important challenges linked to new technologies, especially artificial intelligence and blockchain that has some problems regarding intellectual property, competition law, contract regulation, etc. This challenge, as we can see in the slide, range from the questioning regarding if the synthetic works has to be protected, to who is going to be the right holder in the case of collaborative works created in a metaverse, and also allows the emergence of new products and new infringements. Given that it is impossible to address all these issues in the time that I have for this presentation, I have decided to focus in two of the most controversial because of the disruption that they entail, that are the following one, and I know that these are very controversial topics. First of all, the question of new products. First, the legal nature of NFTs, with a brief consideration of NFTs marketplaces. Secondly, a brief commentary on decentralized metaverses. Regarding NFTs, and I realize that it's a very controversial topic, and we have a very prestigious college that are expert in this field and hold a position absolutely contrary at the position that I will defend. I defend and I believe that NFTs should be considered as a certificate of ownership of personal property of an asset. And this asset can be digital or physical. We should recall that in the various classification of crypto assets that are made by financial market authorities, NFTs are classified as asset-backed digital assets. NFTs are characterized by their uniqueness and non-fungibility. These characteristics endow them with economic interest. Furthermore, it is necessary to disentangle NFTs from intellectual property. First, we must bear in mind that the importance of NFTs lies in their uniqueness, not in their originality of the digital asset that baked the NFT. Second, NFTs can be baked by goods and assets that are not protected by intellectual property. And third, blockchain technology allows the identification of the underlying asset that is assumed to be unique and authentic. These are the characteristics that give this asset an economic interest. And last but not least, NFTs do not currently embed intellectual property rights regarding the digital asset. In other words, if we have as underlying asset a work of art, NFTs only involve the digital corpus mechanicum of this work. Intellectual property rights regarding this work will be established by license external to the NFT. In addition, we find an evolution, as we can see, at the normative level and at the regulation level towards the recognition of digital assets as an autonomous category that can be subject of personal property right. We also have to keep in mind that the dematerialization of assets is, and the recognition of personal property over them is not something that is strange to the law. An example can be found in company law with regard to company shares. Finally, I think that there is a need for uniformity in the treatment of digital assets, especially in the case of crypto assets. I will stress that the Financial Market Authority, you have here, you have the mention of the European Securities Market Authority, have been working on a taxonomy of crypto assets for years. NFTs are considered a separate category. They are not integrated into the financial system either as crypto assets under crypto asset market regulation, as you know it's MiCA, or as financial instruments. As you know, normally we'll know about that, like securities that are regulated under the MiFID II directive. In fact, for the financial authorities, NFTs are understood as certificates of personal property over assets. Well, making this point very quickly, also I will, following from this point, I will briefly discuss the enforceability of Section 4 of the Digital Service Act to NFTs marketplaces. The enforcement of the Articles 29 to 32 will help to avoid many of the infringements that we currently encounter with respect of NFTs. I consider that in the case of centralized NFT marketplaces, these additional provisions applicable to providers of online platforms allowing consumers to conclude distant contracts with traders could be applicable, as the NFT marketplaces fall under this definition. And finally, and I hope I am the time, I try to be very quick, I would like to end my presentation with a comment on decentralized metaverses. As we know, when we talk about decentralized metaverses, we talk about decentralized autonomous organization. And these decentralized autonomous organizations don't have a legal recognition at the moment. So they cannot be considered as subject for the application of law. Consequently, the digital autonomous organization cannot be right holders and they cannot be held responsible in case of infringement. So, although this issue is way more complex, for the sake of argument, we can define this, the governance of the decentralized platform as a governance that is in the power of decision that is in the hands of the members of the platform, the users in a broad sense. I mean, from the creators, the software programmers, the users in the normal sense, and the decision process in this decentralized autonomous organization is made by means of consensus algorithm and a governance smart contract. So in the case of a decentralized autonomous organization, we encounter this granularity that I mentioned in the title of my presentation. This granularity and the fact that the members of the decentralized autonomous organization, of the decentralized metaverse, can be located in different countries, made very difficult the enforcement of intellectual property law, competition law, and digital market regulation. Since we don't have a legal framework regarding decentralized autonomous organization, I would like to launch a proposal that is a little bit ambitious, but well, and this proposal is based in a legal by design approach. This legal by design approach entails that the integration of the obligation established by the EU regulations regarding digital markets into the code of the governance smart contract. This will imply the need for technical standardization, such as the translation of this obligation into code, which is complex, but it is not impossible. So with this proposal that I know that is very ambitious, I will end my presentation and I will look forward for your comments. Thank you very much.
Thank you very much, Vanessa. I would propose now to leave the floor to our two splendid discussants. We have the honor to have with us Gaetano DIMITA from Queen Mary London and Enrico Bonadio from University College London. So from City College London. So basically, we have. You want to? Okay, fine.
I mean, we have 5 minutes. We're 2 Italians, so we should say 2.5 each.
You have two British, 2 Italians, I think. Yeah.
So, I mean, you're more technical and I'm more existential in the line of questioning. So I don't know which is gonna go first.
I go first.
First.
Fantastic presentations covering NFTs, Metaverse, the case law, the emerging case law. You touched on copyright case, Mango, and trademark case, Hermes specifically. And there are interesting issues here. The exhaustion doctrine, you didn't focus much on the exhaustion doctrine, but it has been a case, for example, in Mango, because the court of Barcelona, found that there was an exhaustion of the right of dissemination of the work, right?
Yeah.
It has been criticized. We'll see if the future case law will develop in this case. And also, there was a case that was not mentioned, the Nike versus stock case, which is still pending, as far as I know, on the sneakers, the Nike sneakers. There has been a tokenization of Nike shoes, and the court will probably deal with this issue. And there was another case which I want to mention. It was a preliminary injunction case in Italy regarding the Juventus Football Club a couple of years ago. There, the Court of Rome granted an injunction in favor of Juventus Football Club because an organization, a guy basically minted some NFTs by using the image of football players wearing the Juventus shirt, including Christian Vieri, a famous footballer, and the injunction was granted. But what unites all these cases, I think, is that the courts take for granted that NFTs are digital goods, basically. What was already said by a UK court in the Osborne case in 2022 at the beginning, that was not an IP case, was a digital property case, basically. So it seems that the case law, copyright, trademark, is developing this notion, this concept of NFTs as digital goods, right? Which must be compared to physical goods. So we will see if in the future the case law will continue in this direction. So having said that, just a specific question on the defense in Hermes, right? Mentioned by Joanna. In that case, it seems that the U.S. judge, the New York judge, right? The New York court said you cannot rely on the right to free speech, artistic free speech, to defend this tokenization, right? Because the Grimaldi test was not satisfied. It was not too artistic, it was not commercial. How do you think this case would be resolved in Europe? I know that you mentioned the parody exception, but probably you may want to expand on the fundamental right to the arts under the European Convention on Human Rights or the Charter.
Just
it would be
minute,
interesting. Sorry, I probably exceeded 2 minutes. Sorry.
Should I answer at the end?
Okay, let's give maybe.
Yeah, let's give Gaetano.
Gaetano.
I'll be.
You make the question as well, and then they start.
Yeah, I'll be even quicker at this point because your paper were amazing, and thank you very much for the presentation. I was especially reading the paper. I wanted to know more, and actually wanted to know your position on the general question because. In the last 20 years, we've been obsessed with digitalization, but there are a lot of unintended consequences of this analysis, both of considering, non-commercial use of design in a video game are something that requires tokenization, and even worse when you're thinking about the discussion on tokenization. And the questions are existential, because if you imagine a future in which in a centralized metaverse, I don't like the term, but we cannot change it now, you have the platform that can control everything and can do it better than any UK IP office or any other single trademark or design owner. You just pay Meta a fee and they protect your design or your trademark globally, if it's centralized. If it's decentralized, there is a total lack of interest and opposition of IP owner to have their goods traveling in something they have no control of. So total pure anarchy. Why should you pay on NFTs? So the unintended consequence is if we keep this discussion without thinking about the big picture, we have a future without IP. It's pointless to have IP in this universe. And then we have to think, is it the same place? The metaverse and the real world are the same place? They are converging, or they are totally different? Do we have to use the same rules? In your papers, you were constantly hinting at this question without actually pointing the question out. And the second one that also came out from in your paper, I start noticing, and Enrico does the same mistake constantly, we're obsessed with US case law. We're obsessed with US author. At this point, the follow-up question is there a future of IP? First question. Second, is there a future of our local jurisdiction for more intellectual property? Or we should just abandon and divide the war between US IP law and China? Well, less than 2 minutes?
You know, maybe 3 minutes.
So I think we should, yeah.
I think each and any one,
Each
maybe
of them,
you can give your own interpretation.
Yeah, I think, Joanna, you have 2 minutes to reply, and then we go this way. And we will, we will, Joanna, then Vanessa, then Daylin, then Sara, of course.
Great. Thank you very much for the very useful feedback and questions. In terms of the fair use defense in the US, indeed the US court applied the Grimaldi test. So that's a stricter test when the use concerns an expressive or artistic use. And it's where and the US court recognized that there is the meta-Birkins are at least in some respects artistic works. So it can be satisfied either where there is no artistic relevance in relation to the underlying work, or where the use explicitly misleads the public as to the source or the content of the work. Now, this particular test on appeal, Rothschild appeal, this test should not have been applied, so it's a stricter sort of threshold compared to likelihood of confusion as in all other cases. And because there is a Supreme Court case named Jack Daniels and VIP products. So basically the court accepted that. They said, yes, we did kind of mistakenly apply the stricter test, but even under the likelihood of confusion threshold, indeed the jury would have enough evidence to sort of establish that. Plus, the jury were presented with evidence from actual confusion. So there was a survey to consumers, and they were actually confused as trade origin. So I do agree partly with the US decision, because they said that there is no artistic relevance in relation to the underlying content. I disagree with that, because Hermes may have attempted to make sort of convey critical messages to the use of real leather by Hermes versus the fair free movement in fashion. However, the fact that it was, it involved economic activity, it, well, led to dilution very, very likely. I think well, likelihood of confusion would have been satisfied both under the US as well as the EU regime.
And in Euro, how it would end up?
Well,
in a case like this?
Well, we would rely on the Charter of Fundamental Rights and Freedoms, as well as the European Convention on Human Rights, as well as we would apply the likelihood of confusion test, and obviously, as I already mentioned in my presentation, Hermes use would not abide by the honest practices proviso of the defenses. Same outcome.
Thank you. I would propose to give the floor to Vanessa for commenting as well.
Thank you very much, Professor. Well, this is a very, very interesting question, and I will love to be there to discuss further, because this is one of the topics that I'm working on. I mean, I think that when we talk about decentralized metaverses, there is something that we don't take into account. That decentralized metaverses doesn't mean anarchy. They have rules, and you can trace. You have the traceability of the works. If you are an author, for instance, when we talk about the decentralized metaverses, that allows the creator to have more revenues because we don't have all the commissions regarding the platform. The conditions are established by the creators or by the members of the DAO. This is a very complex topic because we have several kind of also decentralized metaverses. But well, I will just to highlight some things some ideas that I think are important. When we talk about tokenization, that is one of the main points of the metaverse, tokenization was never about intellectual property. It's about finance. It's about digital finance, and the way to obtain more, another way to obtain gains and obtain other ways to have investment in some products. So then we have this improvement that was made regarding NFTs and the link between the digital works and the uniqueness and etc. And the artworks started to be important. And we have to think in two different points. We have to think in one point is the question regarding the digital goods that I think we will have a proper category in some point. And then we have to think about intellectual property. I don't think intellectual property is dead. I think that we can establish, we can continue to enforce intellectual property because of the blockchain allows to the traceability of all the infringement. I think Professor Enrico BONADIO mentioned before the Juventus case. The Juventus case was followed in the blockchain, and the injunction was made in the blockchain. The blockchain allows a lot of a more accurate persecution of the infringement, but we have to develop all of that, and we have to have a better understanding that how decentralized metaverses works. And I prefer a more decentralized structure than a more centralized one, because we know the problems that a centralized metaverse can have regarding competition law and IP. And by the last thing regarding the international, I think we are going we must change to a more international approach regarding some fundamental issues. And this is very complicated, and I know that these are two main blocks of the legislation of jurisdiction. And and we have very important differences. But I think we can find some common grounds and to be able to improve the intellectual property in the metaverse. And I will like to stress one thing, that when we talk about intellectual property rights, and this is the last thing, I'm sorry for the time, when we talk about intellectual property rights, as I said in my presentation, the intellectual property rights are not embedded, for instance, in the NFTs. But maybe we can standardize in the smart contracts some of these licenses and follow the NFT when we talk about an NFT or when we talk about another kind of exploitation in the digital marketplace, the digital metaverse, sorry, that can enforce the IP. And well, as I told you, I think the IP is not dead, and this topic is a very, very broad one, and we have age of discussions, I think. So thank you very much. I'm so sorry because I'm a little bit sick today.
Thank you, Vanessa.
I cannot express myself properly, but thank you.
These were fascinating comments. Daylin?
Okay, I'm going to be brief because of the time. I just want to talk about what you were saying about is Metaverse or are NFT the death of art, the death of IP rights protection. I think that we have to, that IP has an space in Metaverse and in this disruptive technology, but we have to know first the technology. Thinking in the case I was explaining, the principal issue was that the court didn't know the technology, didn't go for the real relation between the NFT and the artwork. So IP is not about the protection of metadata. You can say that, but you can use the benefits of NFT, and we also have talked about use the benefits of blockchain. But at the end, the thing is that NFT is surrounded by speculation and by a no relationship, a real relationship with the artwork. So while this situation is still happening, we can say that NFT is an option for IP creators. That's my thought.
Thank you. Sara?
Yes, very
Last
briefly
word.
too. Yeah, thank you for the questions. Just a very brief reference to decentralized versus centralized. I think that even in decentralized, we will find the problem of co-creation, because normally the users are going to be creators as well of the avatars, of the environment, of everything. So IP is still making sense. The problem is that maybe it's not the IP as we know it, registered by an office and everything. So we have to rethink a little bit of IP in the terms we know it right now. And then the reference you were mentioning, why the US? Well, in my case, because this defense of parody is going to be introduced in design regulation. We don't know exactly why, because in fact in trademarks we don't have something quite similar to parody. So the thing is, what's the most similar thing to that kind of parody in Metaverse? And I found these two cases, Hermes and also Ryder Ripps, that were about trademarks, but well, I thought more or less the same argument in the bottom of the case, because it's freedom of speech and what we can do with the design that is from another person. So I thought as a reference. The only problem I see here is the territorial proxy, because it's true that what's going to be the proxy with a territory and not another one? Why the European Union or USA? Because it's going to be a globalized world, right? So, and in this, I always say, this is an international private law. So I cannot give an answer to that. I would be happy to, but I think it's out of my scope of research.
Okay, the last question. Are NFTs with us now in this room?
Okay, so 30 seconds each. So perhaps I think it is time.